Have you ever signed a document and had that nagging feeling, that little voice asking, "Did I miss something?" Well, what happens when that something is just a simple typo, but with absolutely massive consequences? Today, we're going to dig into the fascinating and, surprisingly flexible world of contract law when a mistake sneaks onto the page. So let's just jump right in with a huge question. Imagine a deal for, say, $200,000. Now, what if a typo in that final contract accidentally changes it to $20,000? Seriously, can one single misplaced zero really blow up an entire agreement? That is the exact problem we're going to solve today. And look, this isn't just some abstract legal puzzle. To really see how this all works, we're going to follow a real story that brings this whole dilemma to life. We're calling it the $1 million typo, or to be precise, the $180,000 typo. All right, so let's meet our two main characters, Charlie and Melby. They've done the negotiating, they've shaken on it, and they have a totally clear verbal agreement. Charlie's selling a piece of land to Melby for exactly 200,000 rand. Perfect. Everybody's happy, everyone knows the deal. But then comes the paperwork. And when the agreement gets typed up, a disastrous error is made. The price isn't our $200,000 anymore. Nope, it's our $20,000. An entire zero just poof, gone. And in their rush, both Charlie and Melby sign it without catching the mistake. And just like that, they have a legally binding contract for a price that is 90% wrong. Ouch. So, what happens now? I mean, your first thought might be, well, it's signed, so that's the final word, right? Is Charlie really forced to sell his land for just a tiny fraction of what they agreed on? Is all hope lost because of one little typo? Let's find out what the law has to say. Okay, so before we get to the solution, we have to talk about the main obstacle. It's this huge, foundational idea in contract law, and it's the biggest hurdle Charlie has to clear. People often call it the Four Corners Rule. Now, the official name is the Parole Evidence Rule. It sounds kind of complicated, I know, but the idea is actually super simple. Once you put your deal in writing, that document becomes the one and only record. A court generally won't let you bring in other evidence, like, say, your notes from a phone call or some earlier emails, to try and change what that final document says. And that nickname, the Four Corners Rule, really helps you picture it, right? If it's not written down inside the four corners of that piece of paper, it just doesn't count. And the reason for this rule makes sense. It's all about creating certainty and stopping people from coming back later and saying, "Oh, wait, but we actually agreed to something totally different." It keeps things stable. So if you just stop there, it really seems like Charlie's out of luck. But, the law is almost never that black and white. Courts have ways of looking beyond just the words on the page to find something way more important, the truth of the situation. And this is the absolute key. Despite that strict four corners rule, the number one goal for any court looking at a contract is to figure out what the people involved actually meant to agree to. This guiding principle is what can finally unlock the whole problem. And courts have a very methodical way of doing this. It's like a step-by-step investigation. First, they read the whole contract, not just the one clause with the mistake. Then they look at the context, the circumstances surrounding the deal. If it's still not clear, they can even look at the negotiations that happened before the contract was ever signed. It's a real process of discovery. And this whole search for the true intention leads us straight to a really powerful legal tool. It's a remedy that was basically designed for exactly this kind of mess. This is the answer to Charlie and Melby's problem. And that tool is called rectification. This is it. This is the official way around the Parole Evidence Rule. It gives a court the power to literally go in and fix the written document, to correct that typo so that the contract on paper finally matches the real deal the parties actually made. But hang on, it's not a free pass. You can't just change a contract because you regret the deal later. To get rectification, you have to prove two crucial things. First, that original true intention, the $200,000 price, and second, that the written document is just plain wrong because of a simple mistake. All right, you've heard the rules, you've heard the exceptions, now it's time to put all that new knowledge to the test. Let's walk through a couple of quick scenarios. It is your turn to be the judge. So first up, remember that last step in the interpretation process I mentioned? The one where a court can interpret a confusing part of a contract against the person who wrote it. So when does a court actually use that power? Take a look at your options here. What do you think? And the correct answer is number 3. only when the clause is ambiguous. Think of this rule as a tiebreaker. It's the court's last resort. The main job is always to find the shared intention. Only when that's impossible do they basically say, well, you're the one who wrote the confusing bit, so this one's on you.
Okay, here we go, the main event. What's the final verdict for Charlie and Melby? Are they stuck with the typo? Is the whole deal just thrown out, or is there another way? What is the right legal outcome here?
And the answer, of course, is number 4. The contract can be rectified. This is where it all comes together beautifully. That big, scary Pearl evidence rule gets set aside because there's clear proof of a simple mistake. The court can and will listen to the evidence about the real $200,000 price and fix the document to make it right. So if you only remember one thing from all of this, let it be this. While we put a ton of faith in written documents, the law's ultimate goal is to enforce the real agreement between people. It's about making sure the actual bargain they struck is upheld, not just blindly following a piece of paper with an obvious error on it. And that really leaves us with a final thought, doesn't it? We always say a contract is a promise, but what this all shows is that the law is constantly wrestling with a much deeper question. Whose promise does it ultimately tell? The one that was imperfectly written on paper, or the one that was truly made in the minds of the people involved? Something to think about. Thanks for watching.